The Copyright Act 2005, Act 690, Section 1. Work eligible for copyright. 1. An author, co-author, or joint author of any of the following works is entitled to the copyright and protection afforded to that work under this Act. A. Literary work. B. Artistic work. C. Musical work. D. Sound recording. E. Audiovisual work. F. Choreographic work. G. Derivative work. And H. Computer software or programs. 2. Despite subsection 1, a work is not eligible for copyright unless A. It is original in character. B. It has been fixed in any definite medium of expression now known or later to be developed, with the result that the work can either directly or with the aid of any machine or device be perceived, reproduced, or otherwise communicated. And C. It is 1. Created by a citizen or a person who is ordinarily resident in the Republic. 2. First published in the Republic, and in the case of a work first published outside the Republic, is subsequently published in the Republic within 30 days of its publication outside the Republic, or 3. A work in respect of which the Republic has an obligation under an international treaty to grant protection. 3. The eligibility of a work for copyright is not affected by its artistic quality, the purpose of the author in creating it, or by the manner or form of its expression. 4. For the purposes of this section, a work is original if it is a product of the independent effort of the author. Section 2. Ideas. Concept excluded from copyright. Copyright shall not extend to ideas, concepts, procedures, methods, or other things of similar nature. Section 3. Grant a government and international body copyright. The copyright of work shall vest in A. The President on behalf of and in trust for the people of the Republic, or B. An international body, if the work is made by or under the direction or control of the President on behalf of and in trust for the people of the Republic, or a specified international body. Section 4. Folklore protected. 1. An expression of folklore is protected under this Act against A. Reproduction. B. Communication to the public by performance, broadcasting, distribution by cable or other means. And C. Adaptation, translation, and other transformation. 2. The rights of folklore are vested in the President on behalf of and in trust for the people of the Republic. Section 5. Economic rights of authors. The author of any protected copyright work has the exclusive economic right in respect of the work to do or authorize the doing of any of the following. A. The reproduction of the work in any manner or form. B. The translation, adaptation, arrangement, or any other transformation of the work. C. The public performance, broadcasting, and communication of the work to the public. D. The distribution to the public of originals or copies of the work by way of first sales or other first transfer of ownership. And E. The commercial rental to the public of originals or copies of the work. Section 6. Moral rights of authors. 1. In addition to the economic rights referred to in Section 5, the author of protected copyright work has the sole moral right A. To claim authorship of the work, and in particular to demand that the name or pseudonym of the author be mentioned when any of the acts referred to in Section 5 are done in relation to the work, and B. To object to and seek relief in connection with any distortion, mutilation, or other modification of the work where the act would be or is prejudicial to the reputation of the author, or where the work is discredited by the act. Section 7. Employed authors. In the absence of any contract to the contrary, the economic right of a work shall vest in an employer or a person who commissions a work where the employed or commissioned author has created the work in the course of the employment or commission. Section 8. Public benefit works. 1. The rights referred to in Sections 5 and 6 of this Act shall not vest in any person in respect of the following works. A. An enactment. B. A decision made by a court or tribunal established under any enactment for the administration of justice in the Republic. C. A report made by a commission of inquiry appointed by the government or any agency of the government and published by the government. And D. Except when news is disseminated by the private media, news, namely a report afresh, Events or current information made by the media, whether published in written form, by, broadcast, or communicated to the public by any other means. 2. The President is a trustee for the public of the works specified in subsection 1 other than works authored by the private media under paragraph D of that subsection. Section 9. Transfer of copyright. 1. The owner of copyright may transfer the economic rights in Section 5 to another person, either in whole or in part, but the transfer, whether in whole or in part, shall not include the moral rights referred to in Section 6. 2. A contract which requires a total transfer of the rights referred to in Section 6 shall be limited in scope to the use provided for in that contract. 3. Copyright may be transferred by assignment, testamentary disposition, or operation of law. 4. An assignment of copyright shall be in writing and signed by the owner of the copyright or by the person authorized by the owner of the copyright for the purpose. 5. A license to do an act that falls within copyright may be oral, written, or inferred from conduct. 6. In the case of joint authorship of a work, an assignment or a license for the work shall be subject to the authorization of the joint authors. 7. Where a work is of joint authorship and one of the joint authors withhold consent to an assignment or the granting of a license, the matter shall be referred to the copyright administrator to determine whether or not consent should be granted in respect of the assignment or license and conditions for the grant. 8. A person dissatisfied with the decision of the copyright administrator may apply to the High Court for review. 9. An assignment, a license, or a testamentary disposition may be made or granted in respect of an existing work or future work. Skip sections 10 and 11. Duration of copyright. Section 12. Duration of copyright in individuals. 1. The rights of the author referred to in Section 5 are protected during the life of the author, and 70 years after the death of the author unless the contrary is stated in this Act. 2. Where work is jointly authored, the rights of the author referred to in Section 5 are protected during the life of the last surviving author and 70 years after the death of that author. Section 13. Duration of copyright in bodies corporate. Where the copyright in a work is owned by a public corporation or other body corporate, the term of protection shall be 70 years from the date on which the work was either made or first published, whichever date is later. Section 14. Duration of copyright in anonymous works. Where a work is published anonymously or under a pseudonym, the rights of the author referred to in Section 5 are protected until the expiration of 70 years from the date on which the work was either first made available to the public, or first published, whichever date is the later, but if the identity of the author is known or is no longer in doubt before the expiration of that period, the rights of the author shall be protected during the life of the author and 70 years after the death of the author. Section 15. Duration of copyright in audiovisual works. In the case of an audiovisual work, the rights of the author referred to in Section 5 are protected until the expiration of 70 years from the date of the making of the work or where the work is made available to the public during that period with the consent of the author, until the expiration of 70 years from the date on which the work was either first made available to the public, or first published, whichever date is later. Section 16. Duration of copyright in sound recording. In the case of a sound recording, the rights of the author referred to in Section 5 are protected from the publication of the sound recording until the expiration of 70 years after the year of publication, or, if the sound recording has not been published from the fixation of the sound recording, until the expiration of 70 years after the year of fixation. Section 17. Duration of protection for expressions of folklore. The rights vested in the President on behalf of and in trust for the people of the Republic in respect of folklore under Section 4 exist in perpetuity. Section 18. Duration of moral rights. The moral rights of authors under Section 6 exist in perpetuity, and these rights shall be enforceable by the author during the lifetime of the author and after the author's death by the author's successors, whether or not the economic rights vested in the author under Section 5 are still vested in the author or the successor in title of the author. Permitted uses of copyright. Section 19. Permitted use of work protected by copyright. 1. The use of a literary or artistic work either in the original language or in translation shall not be an infringement of the right of the author in that work, and shall not require the consent of the owner of the copyright where the use involves a. the reproduction, translation, adaptation, arrangement, or other transformation of the work for exclusive personal use of a person, if the user is an individual and the work has been made public. B. Subject to subsection 2 of this section, the inclusion with an indication of the source and the name of the author of quotations from the work in another work, including quotations from articles in newspapers or periodicals in the form of press summaries, if the work from which the quotations are taken has been made public. C. Subject to subsection 3. 1. The utilization of the work by way of illustration in publications, broadcasts of sound or visual recording for teaching, to the extent justified for the purposes, or 2. The communication for teaching purposes of the work, broadcast for use in educational institutions, or 3. The utilization of the work for professional training or public education, if the work has been made public. D. In the case of 1. An article published in one or more newspapers or periodicals on current economic, political, or religious topics, or 2. A broadcast on current economic, political, or religious topics. The reproduction of the article in a newspaper or periodical, or the broadcast or other communication to the public where a statement of the source is provided unless the article or broadcast when first published or made was accompanied by an express condition prohibiting its use without consent. 9. E. The reproduction or making available to the public by means of photographic works, audio, visual works, or other means of communication of any work that can be seen or heard in the course of a reporting of fresh events or new information, if 1. The work is reproduced or made available for the purpose of reporting by a news medium of fresh events or new information, and 2. The use of the work does not extend beyond that justified for the purpose of keeping the public informed of current events. F. The reproduction of works of art or architecture in an audio-visual work for cinema or television, or in a broadcast by television, and the communication to the public of any of those works of art or architecture if those works are 1. Permanently located in a place where they can be viewed by the public, or 2. Included in an audio-visual work for cinema or television only by way of background or as incidental to essential matters represented. G. Subject to subsection 4. The reproduction in the media or the communication to the public of 1. Political speech delivered in public, 2. Speech delivered in public during legal proceedings, or 3. Lecture, address, sermon, or other work of a similar nature delivered in public, where the use by reproduction or communication to the public is exclusively for the purpose of reporting fresh events or new information. 2. The permission under subsection 1a shall not extend to reproduction a. of a work of architecture in the form of building or other construction, b. in the form of reprography of a whole or of substantial part of a book or of musical work, in the form of notation, c. of the whole or of a substantial part of a database in digital form, and d. of a computer program, except as provided in section 16. 3. Paragraph b. of subsection 1 does not apply in respect of any particular quotations unless the quotations referred to in that paragraph are compatible with fair practice and the extent of the quotations does not exceed what is justified for the purpose of the work in which the quotations are used. 4. Paragraph c. of subsection 1 does not apply in respect of any particular work unless the use referred to in that paragraph is compatible with fair practice and the source of the work. Use and the name of the author are indicated in the relevant publication, broadcast, or recording. 5. Paragraph g. of subsection 1 does not apply unless the reproduction referred to in that paragraph and the number of copies made in the reproduction are limited to what is required in the particular circumstances. 10. 6. Despite the provisions of section 5a, the temporary reproduction of a work is not an infringement of copyright if the reproduction is made in order to make a digitally stored work perceptible or in the process of a digital transmission, a. by a person who or entity that is authorized for that purpose by 1. The owner of the copyright, or 2. Operation of law, and B. As an accessory that occurs during the normal operation of the equipment sued in which is 1. Automatically deleted, and 2. Incapable of being retrieved for any other purpose than those referred to in the subsection. Skip sections 20 to 27. Protection of performers and broadcasting organizations. Section 28. Performers' rights. 1. A person shall not, without the authorization of a performer, a. broadcast or communicate a performance of the performer directly or indirectly to the public, except 1. where the broadcast or communication to the public is made from a previously authorized fixation, or 14. 2. Where the transmission is one that has been authorized by the broadcasting organization that transmits the first performance. B. Arrange a fixation of a performance not previously fixed on a physical medium. C. Exercise the right of reproduction of the fixation in any manner or form. D. Provide the first public distribution of the original or copy of a fixation of performance. E. Provide or obtain a rental of the original or a copy of the performance for the purpose of direct or indirect commercial advantage irrespective of the ownership of the original or copy, rented, or F. Make available to the public a fixed performance by wire or wireless means, in a way that members of the public may access it from a place and at a time individually chosen by them. 2. A performer has the exclusive right to authorize or prohibit a. the rebroadcasting, rental, and distribution of a fixation of the performance. B. The fixation of the performance. C. The reproduction of a fixation of the performance. Or D. The communication to the public of the performance except where the performance has been lawfully fixed on audio-visual or audio recording media, which may be broadcast without the consent of the performer if the recordings have been published, subject to the payment of equitable remuneration to the performer. 3. Where a performer has given a performance under a contract of employment or service. The extent and conditions under which the employer of the performer may use a performance, or authorize others to use it shall be determined by reference to the nature of the contract of employment or service unless agreed otherwise. 4. The consent of the elected representative of a group participating in choral, orchestral, or stage performance shall satisfy the conditions of subsection 2, and where the group has no representative, the consent of the performers belonging to the group shall be expressed by the consent of the leader of the group. Section 29. Duration of performer's right. The rights of a performer in respect to the performance are protected for a period of 70 years starting from the end of the calendar year in which the performance was fixed on a physical medium, or in the absence of such fixation, from the end of the calendar year in which the performance took place. Section 30. Performer's right to contract. Subject to Sections 5 and 28(3), a provision in this Act shall not preclude the right of a performer to enter into a contract with any person on such terms and conditions as the performer considers appropriate for the use of the performance by another person. Section 31. Moral rights of performer. A performer has a right independent of the economic rights of the owner and even after the transfer of those rights. A. To require to be identified with the performer's live oral performances and performances fixed in phonograms, and B. To object to any distortion, mutilation, or other modification of a personal performance, which would be prejudicial to the reputation of the performer. Skip sections 32 to 37. Section 38. The public domain. 1. The following works belong to the public domain. A. Works with expired terms of protection. B. Works by authors who have renounced their rights. And C. Foreign works that do not enjoy protection in the Republic. Section 39. Registration of works. 1. The copyright administrator appointed under Section 68 shall open and maintain registers, in which shall be registered associations of authors, works, and productions. 2. The purposes of registration are A. To maintain a record of works. B. To publicize the rights of the owners. And C. To give evidence of the ownership and authentication of intellectual property. 3. A publisher of work in the Republic may submit the work for registration by the copyright administrator after its publication, and 2 copies of the best edition may be deposited at the Copyright Office. 4. Copyright protection of a work shall not be dependent on the registration of a work. Section 40. Presumption of authorship. 1. An individual whose name is indicated as the author on any work shall be presumed to be the author of the work in the absence of any proof to the contrary. 2. This provision shall also apply where the name used is a pseudonym if the pseudonym does not leave any doubt as to the identity of the author. 3. The presumption of authorship also applies to works created by more than one author. Section 41. Infringement of copyright and related rights. 1. Subject to this act, the doing of an act contrary to a. The rights of an author under sections 5 and 6. b. The rights of a performer under sections 28, 30, and 31. c. The rights of broadcasting organizations under sections 33 and 34 constitutes an infringement of copyright or related right, as the case may be, and the right owner may seek relief in a civil action under Section 44. Section 42. Copyright and related rights offenses. 1. A person who a. Reproduces, duplicates, extracts, imitates, or imports into the country, except for that person's private use, any work. b. Causes to be reproduced, duplicated, extracted, imitated, or imported into the country except for the person's private use, any work. c. Distributes or permits or causes to be distributed in the country by way of sale or otherwise, any work. d. Exhibits or permits or causes to be exhibited in public, any work. e. Removes or alters any electronic rights management information. f. Distributes, imports for distribution, broadcasts, communicates or makes available to the public, works, performances, copies of fixed performances or sound recordings knowing that electronic right management information has been removed or altered without authority, or g. Manufactures, imports, distributes, exports, sells, rents, possesses for commercial purposes, offers to the public, advertises, communicates or otherwise provides any device, product, or component that is designed or adapted to remove, alter, or add electronic rights management information, or h. Circumvents any technological protection measure applied by the right holder to the protected work, or 1. Manufactures, imports, distributes, exports, sells, rents, possesses for commercial purposes, offers to the public, advertises, communicates or otherwise provides without authority devices, components, services, or other means, designed, adapted, or promoted to circumvent such a measure, or j. Rents or lends to the public any work, where the person performing the act knew or had reasonable grounds to know that the action induces, enables, facilitates, or conceals an infringement of any copyright or related right, protected under this act without the license or authorization of the person whose rights are protected under this act, or the agent of that person whose rights are protected, infringes the protected rights and commits an offense punishable under Section 43 of this act. Section 43. Penalty for copyright offense. A person who infringes a right protected under this act commits an offense and is liable on summary conviction to a fine of not more than 1,000 penalty units and not less than 500 penalty units, or to a term of imprisonment of not more than 3 years, or to both, and in the case of a continuing offense to a further fine of not less than 25 penalty units and not more than 100 penalty units for each day during which the offense continues. Section 44. Offenses related to folklore. 1. A person shall not sell, offer or expose for sale or distribution in the Republic copies of a. Works of folklore made in or outside the Republic, or b. Translations, adaptations, arrangements of folklore made outside the Republic, without the permission in writing of the National Folklore Board. 2. A person who contravenes this section commits an offense and is liable on summary conviction to a fine of not more than 1,000 penalty units and not less than 150 penalty units, or to a term of imprisonment of not more than 3 years, or to both, and, in the case of a continuing offense, to a further fine of not less than 25 penalty units for each day during which the offense continues. Section 45. Offenses by body of persons. 1. Where an offense is committed by a body of persons under this act. A. In the case of a body corporate other than a partnership, every director or secretary of the body corporate shall also be deemed to have committed the offense. And B. In the case of a partnership, every partner shall also be deemed to have committed the offense. 2. A person shall not be considered to have committed an offense under this section if the person proves to the satisfaction of the court that the offense in respect of which the person is charged was committed by some other person and was without the consent or connivance of the person charged, and that the person charged exercised the diligence required to prevent the commission of that offense that that person ought to have exercised, having regard to the circumstances. Section 46. Compensation to the victim of offense and forfeiture. In addition to any punishment imposed by the court in respect of an offense under this act, the court may order A. That the sums of money arising out of the offense be paid to the person entitled under this act to those sums, and B. That the reproduction, duplication, extract, imitation, and other material involved in the infringement and the implement or device used in the infringement be forfeited and disposed of as the court may direct, having regard to the circumstances relating to the infringement. Section 47. Civil remedies. 1. A person whose rights under this act are imminent danger of being infringed or are being infringed upon may initiate civil proceedings in the High Court. A. For an injunction to prevent the infringement or prohibit the continuation of the infringement. B. In respect of imported goods or goods ready for export, for an order requiring the customs, excise, and preventive service to detain the goods, or C. For the recovery of damages for the infringement. 2. On an ex parte application, the court may make an order in chambers for the inspection or removal from the defendant's premises of copyright infringing materials which constitute evidence of infringement by the defendant. 3. The grant of an injunction under subsection 1 of this section shall not affect the claim for damages in respect of loss sustained by the applicant as a result of the infringement of the applicant's rights under this act. 4. A person who sustains damage from an infringement of that person's rights under this act may institute civil proceedings against the person responsible for the infringement whether or not the person has been successfully prosecuted under this act. 5. Whether customs, excise, and preventive service, CEPS, detain goods under subsection 1. B. A. The right holder or the person upon whose application the order was made shall provide to the CEPS a sufficiently detailed description of the goods to make them readily recognizable by the CEPS. B. The CEPS shall release the goods to their owner if within 10 working days it is not informed by the person upon whose application the order was made that 1. Proceedings leading to a decision on the merits of the case have been initiated by a party other than the owner of the detained goods, or 2. An extension of the order for the detention of the goods have been granted by the appropriate authority. 6. A right holder may apply directly to the CEPS for the detention of goods upon the grounds stated in subsection 1b, and subsection 5 shall apply to such an application as appropriate, except that before the application is granted, the applicant shall provide sufficient information to satisfy the CEPS that there is an infringement or imminent infringement of the rights holders, copyright or related right. 7. Upon receipt of an application under subsection 6, the CEPS shall within 14 days inform the applicant of A. The decision of the CEPS on the application, and B. Where the application is granted, the period of the detention of the goods. Section 48. Settlement of disputes. 1. Where any dispute arises between any parties under this act or in relation to any copyright or claim under this act, the parties involved in the dispute may seek to negotiate a settlement of the dispute. 2. When negotiation under subsection 1 fails, a report may be made by either or both parties to the copyright administrator, who shall mediate for settlement. 3. A party dissatisfied with a decision to submit to mediation made under subsection 2 may seek redress from a court of competent jurisdiction. Section 49. Collective Administration Societies. 1. Authors, producers, performers, and publishers may form collective administration societies for the promotion and protection of their interest. 2. A collective administration society may, acting on the authority of the owner of a right, collect and distribute royalties and other remuneration accruing to the owner. 3. The minister may by legislative instrument make regulations for the formation, operation, and administration of societies. Section 76. Interpretation. Author means a person who creates a work, and in the case of cinematographic work or sound. Recording means a person by whom the arrangements for the making of the work or recording is undertaken. Derivative work means a work resulting from adaptation, translation, or other transformation of an original work in so far as it constitutes an independent creation. Fixation means the embodiment of sounds, images and sounds or representations, made from them from which the sounds, images and sounds can be perceived, reproduced or communicated through a device. Literary work includes A. Novels, stories or poetical works. B. Plays, stage directions, film scenarios or broadcasting scripts. C. Textbooks, treatises, histories, biographies, essays or articles. D. Encyclopedias, dictionaries, directories, timetables, anthologies, databases or compilation of data or other material, whether in machine-readable form, which by reason of the selection or arrangement of contents constitutes intellectual creations. E. Letters, reports or memoranda. F. Lectures, addresses or sermons. And G. Computer programs, whatever may be the mode or form of expression. Owner means a person to whom the copyright in a work belongs and includes the heir of an author or an assignee in whole or in part of a copyright. Performance means a presentation of a work by such action as dancing, playing, reciting, singing, delivering, declaiming, or protecting to listeners or spectators. Performer means the actor, dancer, musician, singer, and other persons who act, sing, deliver, declaim, play in or otherwise perform literary or artistic works or expressions of folklore. Producer means a person or an entity that A. Finances or organizes 1. Stage performances, or 2. Productions, or B. Undertakes the first fixation of audiovisual work or sound recording. Public performance means A. In the case of a work other than an audiovisual work, the recitation, playing, dancing, acting, or otherwise performing the work either directly or by means of any device or process. B. In the case of an audiovisual work, the showing of images in sequence and the making of accompanying sounds audible. And C. In the case of a sound recording, making the recorded sounds audible at a place or at places where persons outside the normal circle of the family and its closest acquaintances are or can be present, irrespective of whether they are or can be present at the same place and time, or at different places or times, and where the performance can be perceived without the need for broadcasting or communication to the public within the meaning of the definitions of broadcasting and communication to the public. Public place means any building, place, or conveyance of which for the time being the public are entitled or permitted to have access, either without any condition or upon condition of making any payment, and includes theaters, hotels, cinemas, concert halls, dance halls, bars, clubs, sports grounds, holiday resorts, circuses, restaurants and commercial banking and industrial establishments.